On the record of the State of Ohio versus Raymond Tennessee, B 1503961. Here are three separate motions in limine. I have received the motions and the response from the defense. State, it's your motion. Go ahead.
As I was going to be addressing the marijuana found in the car, one of the things I know we discussed earlier with Mr. Matthews, we had told him that we were not going to call anyone from the DeVos family as far as the character of the victim, in this case, Mr. DeVos. As a result, we did not think anything about his character or background was relevant. At the same time, we told defense counsel that if indeed the offense with the character of the defendant in issue of the case, that there were certain things that we provided him to discover that we were prepared to use. We were not going to use those in our case in chief. We did not feel we could. But just basically, as an overabundance of caution and discovery, if he were to testify as to his good character, these were some of the things we would bring out. We think the same thing applies here with the victim in this case. We are not going to call anyone from the family. The only person called about Mr. DeVos will be the owner of the car that he was driving. And she is going to say that she was the owner of the car. She's not going to talk really anything about him. So out front, we are not putting Sandy DeVos' character in issue. With reference to the marijuana found in the car, Judge, first I state that the car was not owned by Sandy DeVos. He was driving the car of someone else. Based on the search of the vehicle after this happened, there were 2 bags of marijuana found in the center console. There was an orange also contained 2 bags of marijuana, and there was a glass jar found on the floorboard behind the front driver's seat that also contained marijuana. The defendant in his statement never indicated at any time that he saw any type of contraband at all, other than the 1 bottle that was labeled gin that he took out of the car. So since it was not in plain view and there was no indication by the defendant that he saw it or took it into account when he was getting Mr. DeBose out of the car, we fail to see its relevance, and we would ask the court to exclude any testimony about it being brought up in trial.
Judge, will we argue the other matters, or do you want to go on that matters? All right, Judge, the second prong of that motion in limine has to do with the marijuana found in Samuel DeBose's system during the autopsy. And for that, Judge, I think I have the witness that would be the person who would testify at trial if it were necessary. Bob Poplar, toxicologist from the Coroner's Crime Lab, and I'd ask Bob to come up and be sworn, just tell the court exactly what he can and can't say about that.
Very good. Oh, right over here, sorry. It's on the back of the base of the microphone. And I apologize, Mr. Topmiller, I had you sit down first. Could you just raise your right hand? You're fine seated. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very good.
Before I proceed, Stu, do you have any question about his qualifications? Do I need to qualify him as an expert?
Very good.
Sir, would you state your name for the record, please?
My name is Robert G. Topmiller, Topmiller.
And what is your position and title, sir?
I am the Chief of Toxicology at the Hamilton County Coroner's Office.
All right, you do analysis of bodily fluids?
I do, yes.
All right. And is it the routine practice of the coroner's office when they perform an autopsy on a deceased person to draw a certain amount of that person's blood?
Yes.
And is that then submitted to your division for analysis for a toxicological evaluation?
Yes, it is.
All right. Was that done in this case with regard to Samuel DuBose?
Yes.
All right. And you did an analysis on it to determine, and among other things, you're looking for controlled substances in the person's system?
Well, our analysis typically is to determine if any volatiles such as ethyl alcohol are present, to do an ELISA presumptive drug screen to look for abused drugs as well as some prescription medications that may be abused. And then depending on what we find at the ELISA screen, there may be more confirmation, other testing to confirm those results.
And was that in fact done in the autopsy of Samuel DuBose? Autopsy blood was drawn, was analyzed?
Yes, it was.
And what substances did you find?
We found the analysis determined that there was marijuana THC in the system as well.
Which is the active ingredient?
Yes, THC is the main active ingredient in marijuana. There are also 2 metabolites that are formed from the THC.
It breaks down?
Right, there's the active ingredient alpha or hydroxy marijuana THC, and then also a THCA or carboxy THCA.
Now, as a toxicologist, do you have any concerns about the reliability of what you found as to whether those substances were in Mr. DuBose's system at the time of his death?
Yes, there's issues that occur when someone dies in regards to the distribution of drugs post-mortem.
Obviously, in the case of Samuel DuBose, this was blood drawn as part of his autopsy, so it was in fact a post-mortem blood draw. Is that correct?
That's correct.
What happens when a person dies if he has marijuana in his system?
Well, what happens, there's a phenomenon called post-mortem redistribution where certain drugs, especially marijuana, may redistribute from the tissues or the fat cells in your body after death and redistribute back into the blood. And so there's a question that has not been determined yet as to what extent this redistribution of any marijuana, THC, or metabolites may have come back from the cells of someone who has smoked marijuana in the past, and once they die, it goes back into the blood. To what extent that is, and not being able to determine from those blood levels exactly what may have been their level at the time of death.
So I understand this, in a case such as this one, where the blood is actually drawn 12, 15, or maybe 18 hours of death, what you find in that blood is not going to necessarily reflect what was in the blood at the time of death.
That's correct.
In this case, in looking at the blood of Samuel DuBose and the toxicology exam that you did, are you able to tell us anything about when he had last smoked marijuana?
No, I cannot.
It could have been hours before death. It could have been days before death.
Yes, could have been.
Okay, we can't say when it was smoked or taken into his body.
That's correct.
Can you say anything about the level of THC or marijuana in his body at the time of his death?
No, I cannot.
Can you say anything about the effect any marijuana would have had on him at the time of his death as far as impairing him or affecting his judgment?
No, since I have no idea whether the marijuana was actively going on at the time of death, I can't make a statement as to impairment.
Would it be fair to say that the only thing you can tell from this blood draw is that at some time prior to his death, and you can't say when, hours, days, is that at some time before his death he had smoked marijuana?
That's correct.
That's all you can say about
All
it.
I can say is, based on the fact that we've seen all the metabolites present, that he was exposed to or ingested marijuana sometime prior to his death.
I don't have any further questions.
Very good, Mr. Ross.
Mr. Coppola, in response to one of Mr. Gibson's questions, you indicated that it may have been, or it could have been days or weeks before the death of Samuel DuBose that he ingested marijuana.
It could have been, as someone ingests marijuana, if they're a regular user, it takes a bit of maybe days, weeks for the marijuana and the metabolites to leach out of the tissues into the blood and out the urine. And so I'm not sure, it could have been a few days before, it could have been a few hours earlier, it could have been days later, I don't know.
It could have been a few minutes before.
It
correct?
could have been.
Okay. And when was the autopsy performed, or when was that blood draw done with reference to the time of his death?
Well, I can tell you that based on the chain of custody that was initiated at our office, the blood that we sampled was taken on 7/20 of 15 at 8:15 in the morning.
Okay, and if the time of death was roughly 6:30 p.m. the night before, that'd be almost 14 hours later, correct?
Correct.
And you are unable to say, because there are no studies that have determined how long it takes that THC to leach out of the body fat back into the blood?
That's correct. There's studies that have been going on for years. There's no doubt that marijuana has this post-mortem redistribution issue. It's yet to be determined to what extent that is, and as a result, no one seems to really have a good handle on the correlation between the levels you find post-mortem and what they may have been at the time of death.
Okay, what were the levels that you found post-mortem?
The levels we found for the marijuana THC was 0.018 milligram per liter. The marijuana metabolite, which is the OH-THC or the hydroxy-THC, was 0.009 milligrams per liter. And the marijuana metabolite, the carboxy-THC, the THC-COOH, was 0.076 milligrams per liter.
Okay, if you got those results from blood drawn from a living human being, what would that indicate to you?
To me, it would indicate that the person has ingested marijuana very recently, that they would be impaired because of the fact that the levels are pretty high.
And when you say impaired, what do you mean?
I mean that the person, when they were driving, would be experiencing behavior that would be consistent with the effects of marijuana when driving.
And the person would be
legally under the influence of, driving under the influence of marijuana in the state of Ohio.
Well, they certainly would be above the per se level of 5 nanograms per milliliter or 0.005 milligrams per liter, yes.
And considerably above that per se level, correct?
Correct.
Okay. Now, I note I was furnished with a copy of your toxicology report. I note there were also 2 other drugs found in Mr. DeBose's blood. Is that correct?
That's correct.
One of those was fluconazole.
That's correct.
That's for the court reporter, Fluconazole. And the second was trimethoprim.
Correct.
And that's Trimethoprim, correct?
Correct.
What are those 2 drugs?
The fluconazole is an antifungal agent. If someone has a fungus issue. The trimethoprim is an antibiotic for infections.
An antibiotic?
Antibiotic used for infection.
Okay, and are those prescription drugs?
I believe they are.
And are they drugs that are subject to abuse?
No, I don't believe so.
Are they drugs that are redistributed post-mortem, as with the THC?
I do not know.
Okay. And you didn't do any quantitative analysis of those drugs to determine the level in Mr. DeBose's blood?
No, we did not.
Have you ever run across those drugs as drugs of abuse during your time with the coroner's office?
No, I've never seen them as drug of abuse. I've seen them from time to time in post-mortem samples. So we've seen these, but never related them to any sort of abuse situation.
I have nothing further.
Thank you. Redirect?
One question. Not all drugs are subject to this redistribution post-mortem, is that correct?
Not all drugs. All drugs seem to have maybe a little bit, to some extent, a degree of post-mortem redistribution. Things like alcohol, cocaine, morphine, not too much. Drugs like tricyclic antidepressants, fentanyl, marijuana certainly have that problem going on. And there's different categories of drugs. So everything, to some extent, there's some redistribution going on. Certain drugs have a lot more of that happening than others.
And for example, alcohol, it doesn't have that redistributive post-mortem effect.
Not very much, if hardly at all.
So for the most part, that drug, if the blood is drawn at autopsy, you could analyze it 15 or 18 hours and not see this effect that you see with marijuana.
Certainly not to the extent that we see in marijuana, no.
Okay.
Very good. You may step down, Mr. Miller.
Thank you, Your Honor.
Thank you so much for being here.
You're welcome.
Is this witness excused?
Yes, Judge, I don't
Any
think-
objection?
No objection for the purposes of this hearing.
Yes, yes. You are free to go today. Thank you.
Judge, obviously, it's the state's opinion that the expert, Bob Topmiller, who performed these analyses, can't tell us that those examinations he did on Sam Dubos's blood show anything other than that Samuel Dubose ingested marijuana at some point. It could have been hours and it could have been weeks, days or weeks before this was done. And he explained to you why that there's this distributed property of marijuana when it occurs, when the blood is drawn after death. He would not venture to say on the stand that this marijuana in his system, he could not say that it had any effect on Samuel Dubose, that it impaired him in any way. He couldn't say what level that was in Samuel Dubose's body at the time of death. And finally, he could not tell when it was ingested. Therefore, anything about that is pure speculation, and there's no relevance to it. All that the introduction of that evidence would attempt to do would be to show that Samuel Dubose uses marijuana and therefore put him in a bad light. It's prejudicial and is irrelevant to the matters at hand. Let me move on, Judge, to the 2 other motions that we filed. There's a motion in limine with regard to Samuel Dubose's record. Mr. Matthews has made it clear he intends to try to subpoena the clerk of courts and have someone come up and put on the record what criminal convictions Samuel Dubose has. I don't know what authority he would have for that, but it's certainly not relevant. The evidence rules establish certain limited criteria when we can introduce prior convictions, for example, to elevate an offense or show a specification or to impeach. That's not what this is for here. Again, Mr. Matthews is simply trying to show that he has a criminal record and therefore he's a bad person, not relevant and certainly prejudicial. Finally, the defendant has made it clear his intention to introduce evidences of Samuel Dubow's medical condition. He's issued subpoenas to various hospitals around town seeking information on Samuel Dubow's medical condition. I think, again, Judge, he's clearly trying to show that Samuel Dubow has a medical condition that he thinks will put him in a bad light in front of this jury. There's certainly no relevance to the matters that are before this court in trial. The motions in limine we filed, Judge, we just want to get a clear ruling because all these things are so clearly irrelevant that the court should make clear to the defendant right now at this early stage of the proceedings that these issues aren't to be brought before the jury, especially as we start with voir dire next week.
Judge, since this case began, I've heard the word over and over again, transparency. From the leaders or the so-called leaders of the city of Cincinnati, the so-called leaders of the University of Cincinnati, the prosecutor's office, and as recently as last night on the news, I saw Bishop Bobby Hilton on the steps of this courthouse saying all we want in this case is transparency. Believe it or not, Ray Tenzing and I want transparency also in this case. But apparently we all have a different definition of what transparency is. The state has filed these 3 motions in limine to try to suppress evidence that we feel is very relevant and probative in this matter. All of the things are related to things that were part of Sam Dubow's life on July the 19th, 2015. My research on a motion in limine suggests that we are required, if the court grants these motions in limine, to proffer the evidence that we think is admissible and to make a record to show why we, or where that fits into the whole pattern and what the issue is. And that's what I want to do here today with this hearing. I'd like to deal with each one of these motions independently to build a record just in case a court down the line somewhere has to review what went on here. To understand the motions, Judge, the facts in this case have been widely reported that Sam Dubow's was shot by Officer Ray Tenzing because he drove away from a traffic stop for no front license plate. That is barely the tip of the iceberg of what went on here. And it's our position that Sam Dubow's drove away at a very rapid pace, accelerating with Ray Tenzing trapped in that car, and that as Ray Tenzing was going down, being dragged, that's when he fired his weapon in order to preserve his own life or keep from being grievously injured. After the entire incident was over, there were searches done of Sam Dubow's car. His body was taken to the coroner's office. Various things were discovered that are the subject of these motions that we think played a very important role in determining it. The question is, why would Sam Dubow's take off from what they call a routine traffic stop, if there is such a thing? Well, these issues that are before the court today answer that question. And I think a jury in this case, that's going to be the primary question on our minds, is what was going on here. We are not attempting to assassinate the character of Sam Dubow's. We want all the facts out before this jury so that they can make a rational and intelligent decision. Now, with reference to and I'll take it in the order that makes most sense to me, with reference to the level of marijuana in Sam Dubow's body, when Ray Tenzing made the traffic stop, and it's all on the video, when Sam Dubow's rolled by him with no front license plate. That's what drew Tenzing's attention to Dubow's. Tenzing did not know whether it was a man or woman driving the car. The individual had a red hat and red shirt on. But when the car went by him, Tenzing observed the license plate that was on the rear of that vehicle. He ran that license plate on the computer in his cruiser, and that's visible on the body cam. He His computer in the cruiser immediately told him that the car was registered to a female, DeShonda Reed, and that her license was suspended. On that basis, Ray Tenzing decided to initiate a traffic stop, something he was required by his oath to do and something he was required by his employer to do. That traffic stop, DeBose rolled on down Vine Street toward Phil. Tenzing got in behind him. He started to initiate the traffic stop. DeBose turned on to Phil Street off of Vine, which was good as far as Tenzing was concerned because he was getting out of the traffic of Vine Street. However, once DeBose got onto Phil Street, he did not pull over immediately, despite the fact that Tenzing had his cruiser lights on and he used his siren to yelp a couple times. Tenzing called out his location as he's supposed to do on his radio to this dispatcher and to any other UC officers who were listening, and he said that DeBose was slow to stop. Now that's an indication to those other officers that there's nothing terrible going on here, but something is not quite right. DeBose continued on to Rice Street. He turned right on Rice Street and finally pulled over. Tenzing pulled over behind him, exited his cruiser, and went up to DeBose's driver's side door, made contact with Mr. DeBose. He told him who he was, why he was stopped, and he asked him for a driver's license. Mr. DeBose never did provide a response despite multiple requests for a driver's license. And at some point during this back and forth, Officer Tenzing could see on the floorboard between Mr. DeBose's legs a bottle that was marked gin. And Officer Tenzing asked DeBose, "What is that?" And DeBose handed it to him and said, "This is air freshener." Well, the evidence is going to be that Ray Tenzing and other police officers recognize air freshener as something carried by people who potentially are transporting drugs, because the theory is that that air freshener smell will throw off a drug dog if he's brought around to sniff in the car. Tenzing set the bottle on the roof of the car and continued to inquire about whether Sam DeBose had a driver's license. Sam DeBose never would answer him, and finally Ray Tenzing said to him, "Until I can determine who you are, go ahead and take your seatbelt off." And at the same time he reached to open the car door, and that's when this entire incident went from non-compliance to a violent outcome. Ray Tenzing's suspicions or whatever were heightened as a result of the actions of Sam DeBose up to that point, and in fact were verified by everything that occurred after that. The level of marijuana in Mr. DeBose's system, even though Mr. Topmiller can't say that that's what it was at that precise moment, and he can't tell when DeBose last smoked marijuana, as Mr. Gibson pointed out, whether it was days or weeks before or hours before. Mr. Topmiller also agreed it could have been minutes before. But the fact that there was marijuana in Sam DeBose's system at a level that Topmiller says, had it been drawn from a living human being, would have been per se illegal in the state of Ohio for purposes of the OVI statute. That's important because it may explain some of the reasons that Sam DeBose didn't want to get caught. Then we go from there to the marijuana that was recovered in the car. And it's not mentioned in the motion, but I assume that they're also going to ask that any reference to the marijuana that was recovered at the coroner's office out of Sam DeBose's clothes and the cash that was recovered there also not be mentioned. And I'll agree, Tenzing didn't know about any of that stuff. But again, it's all relevant evidence. It's evidence of what DeBose was up to. And then we get to the prior record. And I have, just in my own little cursory search of the clerk of courts here in Hamilton County, nowhere else, just Hamilton County, I have certified copies of records of his convictions, 46 convictions related to drugs or driving without a license. There's a total of 5 felony convictions, 2 of them for trafficking in marijuana, 1 for permitting drug abuse. There's 21 possession of marijuana convictions, misdemeanors, and there are 25 driving under suspension or no driver's license convictions. I think all of that is relevant because it shows that Sam DeBose, number one, certainly couldn't have been afraid of getting a ticket for not having a front license plate or getting a ticket for driving under suspension. He'd been through that process enough, and he was still out free to drive and wasn't worried about whether he drove with a license, and I'm certain that he wasn't concerned about a ticket for those type of offenses from Officer Tenzing. But you add in the fact that he's already got felony convictions for trafficking in marijuana, and apparently he's got enough marijuana in the car somewhere. The evidence that's been given to me is that there was between 200 and 1,000 grams of marijuana in that car and on his person, and that amount arises to a felony level in the state of Ohio. That gives him a whole lot of incentive to try to get away. Now, you add that to the medical records that I've been subpoenaing all over town. Well, I issued a subpoena to Good Samaritan Hospital where Sam DeBose was treated for this condition that afflicted him, that I think played a major role in his decision to leave, because I think Sam DeBose had been around enough to know that he wasn't going to drive home from that traffic stop. He was going to jail if Ray Tenzing had ever been given a chance to discover the contraband in the car and everything else, and his being under the influence of marijuana. For that reason, and because of the medical issue, I believe that Sam DeBose had plenty of reason to flee, and that explains his actions here that day. Now, the state, and I have not subpoenaed records from hospitals all over town. I subpoenaed records from University Hospital that pertain to Ray Tenzing, the treatment he received, and I subpoenaed records from Mercy West Hospital and Mercy Family Practice in Montford Heights, both pertaining to Ray Tenzing because of medical testing that he was forced to undergo as a result of his contact with Samuel DeBose. And I'm specifically not saying what those records are all about.
I appreciate that.
But I think that issue, which you're aware of, is very pertinent and relevant to this trial. And I would note that the prosecutors have on their witness list a fellow by the name of Mark Ehlers. Mark Ehlers is associated with a group called the Kroll, Kroll Company, Kroll Group, whatever it is. They were commissioned by the University of Cincinnati immediately after this happened to investigate Ray Tenzing's actions on July 19, 2015. And basically their report throws Ray Tenzing under the bus and points out everything in the world that he may have done that they concluded was wrong. A lot of it's based on factual inaccuracies, in my opinion. But the one thing they say in the Kroll report that I think is very relevant here, which I expect Mr. Ehlers, if he's going to testify, will say, is that the presence of illegal contraband, however, and the fact that DeBose was driving under suspension may be relevant to show DeBose's then existing state of mind and perhaps to explain why DeBose was apparently anxious to drive away from the traffic stop. Judge, I would submit that had Kroll known at the time that they did their investigation, beyond the contraband that was in the car, of the blood level of THC and the medical condition which afflicted Mr. DeBose, I think they would have added those in as relevant factors to explain why he was so anxious to leave this traffic stop. Judge, I would submit that Ohio Rule of Evidence 401 defines relevancy, and I think it fits perfectly with every one of these items. I would further add that with reference to the prior record, Evidence Rules 404A2 and B are also very appropriate, and on the basis of common sense, the rules of evidence, everything that the state is seeking to suppress here does have relevancy and probative value, and the motions in limine should not be granted. Thank you.
First off, I don't think why Sam DeBose fled is relevant. The fact of the matter is this video is going to show that, in fact, he did try to flee. Why he did, to put an answer to that requires speculation. I know Mr. Matthews was just speculating repeatedly on why. Was it the marijuana in his car? Was it his medical condition? These are just ways he gets these negative character incidents before the jury. and I would suggest that that makes this evidence prejudicial and not proper. He said that the level of marijuana would show that he Sam DeBose was under the influence. We don't know what the level of marijuana was. That's very clear from Bob Topmiller's testimony. To say that, we have to completely speculate, and there's no evidence that's ever going to clear that issue up. To talk about his prior record, 99 times out of 100, Mr. Matthews isn't going to be sitting at that table representing a police officer, and he's going to be representing someone who has a criminal record. You can imagine what he's going to do if the people from our office, the prosecutors, come in here and try to convict his clients by using certified copies of judgment entries of criminal convictions. He's going to say it's irrelevant, it's prejudicial, and it's not properly admitted. He talks about the Kroll report. The Kroll report is not a criminal investigation, Judge. They were asked to come in and do an investigation by the University of Cincinnati to see whether their employees violated their rules and procedures. Again, he opines that Mr. Ehlers did not put Sam DeBose's medical condition in that report and suggested that he would had he known about it. I would suggest to the court that Mr. Ehlers did in fact know about it, and he didn't put it in that report because he indeed deemed that it was not relevant and so did not give it that any weight. Judge, he talked about transparency. Transparency is all well and good, Judge, but what transparency is in our case is a free, open, and public trial. And that's what we're going to get. It's not the right to introduce whatever he wants to try to taint or tarnish Samuel DuBose. What we are here, Judge, is bound by the rules of evidence, and I would suggest to the court that the things he wants to bring in are simply character assassination evidence and don't have any relevance on the matters to be decided by this jury. That is, did Raymond Tensing purposely cause the death of Samuel DuBose, and if so, was it justified under the law of self-defense? Those are the issues before this jury, not whether Samuel DuBose was ill, not whether he had marijuana or marijuana in his system.
The Ohio Rules of Evidence, Rule 401, defines relevant evidence as relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Going further on that, under Rule 404, the character evidence of a victim, evidence of a pertinent trait of character of the victim of a crime offered by the accused or the prosecution to rebut the same, or evidence of a character trait of peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor is admissible. And then it goes on about the various rape exceptions. 404 also addresses the other crimes, wrongs, or acts, and it specifically say it may, however, be admissible for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, to admit other crimes, wrongs, or acts that would otherwise be inadmissible. With regard to the marijuana in Samuel DuBose's system, the probative value is substantially outweighed by the danger of unfair prejudice, of confusion of the issues, or of misleading the jury. There is no scientific ability to determine when the Samuel DuBose last ingested marijuana, and it would be inappropriate to allow that evidence. So the motion to eliminate with regards to that piece of evidence is granted. The same regarding the criminal record of the defendant. 5 felony convictions, 21 weed tickets, 25 driving under suspensions or no operator's license. The rules are clear when prior records come in, and even with an extensive record like that, it's clear that the probative value is substantially outweighed by the danger of unfair prejudice, and it frankly has no place in this trial. The medical condition of which Samuel DuBose suffered it's a leap. It's a leap to say that his medical condition influenced his decision of how he behaved that day at the scene when stopped by the defendant. With regards to the marijuana that was in the vehicle, it was pretty clear that there was multiple locations of marijuana, including on Samuel DeBose's person, that with regard to the argument that there was flight in this case, that the presence of those drugs in the vehicle would have affected Samuel DeBose's decision. And this is not based on what the Kroll report says whatsoever, because as the state pointed out, that is not a legal criminal investigation in any sense of the word, and the conclusory opinions that they render have no effect on this court's decision. It is appropriate that the marijuana that was found in the vehicle come in during the course of the trial if the defense so chooses to present that. So the motion in limine with regards to the marijuana that was found in the vehicle and on his person is admissible, and the motion in limine is overruled with regards to that. Anything further from the state? Anything from the defense? Very good.